permissive reliance of confidential information. In certain situations, persons can use information deemed to be confidential even if there was no specific authorization granted by the trade secret holder for such use. This permissive reliance on confidential information holds a special place in the realm of data exclusivity. Data exclusivity or exclusivity of registration data is the period of non-reliance or non-disclosure that is provided to new chemical entities, pharmaceutical compositions, and agrochemical registration data or test data. Since India does not have a statute that protects such data for a specified period of time, inventors rely on common law principles under trade secrets law. In the case In re SmithKline and French labs, the United Kingdom held that confidential test data regarding safety, efficacy, and quality of the medicinal product for the grant of marketing license can be used by the licensing authority in the discharge of its duties. The court held that the licensing authority can use such confidential information as long as it is under the authority of the statute and foremost it is in the interest of the public. Thus, public interest would enable Indian courts and adjudicatory bodies to rely upon the permissive reliance standard in carrying out their functions comprehensively and efficiently. Now, we will come to the most litigated part of trade secrets law, obligation of confidence through employment. A covenant not to compete or a non-disclosure clause in a contract of employment, which are provisions routinely executed in the course of business, are forms of agreements that may carry an obligation of confidence. A non-disclosure clause during the course of employment has been upheld to be valid. However, after the employment concludes, the validity of a non-disclosure clause or a covenant not to compete has been questioned before the Indian courts as a restraint of trade under Section 27 of the Indian Contracts Act. While courts in India have not yet set a precedent on post-employment confidentiality obligations, there could be cases where a restraint reasonably limited by time, geographic area, etc. could be held to be valid. Protection of an idea. This is important because courts in a common law system are often faced with the question of whether an idea which is not yet concrete ought to be protected, and to this end they have examined the relationship between the parties as either an implied contract or a quasi-contract. Under an implied contract, usually a person does not stop another person with the idea from disclosing it to him. Under a quasi-contract, a person using an idea is unduly enriched or the idea is thrust upon a person when such trade secret is disclosed. Indian courts have ruled that it is necessary to examine the concreteness and novelty of the idea to determine the existence of a confidential relationship. Element 3 is the unauthorized use of confidential information. Infringement of a trade secret can be in two specific forms: misappropriation of a trade secret and its variants, and a breach of confidence. Misappropriation of a trade secret is where the trade secret has been wrongfully acquired by a third party. One example of trade secret misappropriation is the famous case in the United States of E.I. DuPont versus Christopher. In this case, DuPont alleged that the defendants misappropriated its trade secret for a process of making methanol by flying over its factories and taking photographs that would enable a skilled person to deduce the process. The court in this case held that a trade secret holder is only required to take reasonable precautions and that misappropriation of such trade secret occurs when there is an unlawful taking of a trade secret without expending any effort by techniques such as reverse engineering or independent research. Next, breach of confidence. In relation to a breach of confidence, the trade secret holder is required to have either expressly or impliedly disclosed the trade secret to a third person. Where the use of a trade secret by a third party is beyond the scope of the authorization granted, such act by the third party is also considered a breach of confidence. A breach of confidence claim may arise either from an express or implied relationship of confidence between the parties. There are several remedies available to a trade secret holder depending on the nature of infringement. Where the infringement is in the nature of misappropriation, the trade secret holder can seek both civil and criminal remedies. However, where the infringement is in the nature of a breach of confidence, only civil remedies are available to the trade secret holder. Under criminal law, the trade secret holder may file a case for theft, trespass, and cheating where there is misappropriation of a trade secret. Under civil law, a person whose trade secret has been misappropriated or there has been a breach of confidence can seek a permanent injunction restraining the infringer and any unauthorized beneficiaries from using the trade secret, a direction from the court for delivery up of all the confidential information where possible, and third, compensation or damages for losses suffered due to disclosure of trade secrets. This chapter aimed to provide an overview of the basic principles of trade secrets law and the application of those principles. The situation may change if and when India decides to enact the National Innovation Bill, which codifies the standards for disclosure and protection of the trade secrets. Until then, information is protected as a trade secret between parties in line with principles of common law and precedent.